Welcome back to another edition of Between Two Fars. I'm Warneke Miller, and I'm joined by Judge Reid Prouty from the Armed Services Board of Contract Appeals. He is a vice chairman and has been talking with us and giving us an insider look at some of the basic things that you're going to face if you've got a case in front of the Armed Services Board of Contract Appeals. Today, we're talking about motions to dismiss. When is a motion to dismiss appropriate?
Sure. Generally, it's appropriate for the same reasons you would file a motion to dismiss in federal court under Rule 12. Now, as I discussed in the earlier episode about sort of the 30,000-foot view of the board, our rules are a little bit vague about motions to dismiss, but we sort of hew to a large degree the federal rules of civil procedure. So the things you might think of as a Rule 12 motion under the FRCP, 12b1 jurisdiction, 12b6 failure to state a claim, those are the sorts of things you can file a motion to dismiss about at the Board of Contract Appeals. So for example, the classic one is about the appeal not being done within the 90-day statutory period. That is jurisdictional. So if the contractor received the COFD one day and then 100 days later is when they submitted their appeal to the board, well, that might be the basis for a motion to dismiss, which you could file and the judge would consider. By the way, it's a merits decision, so ultimately for a motion to dismiss, it's going to wind up being a 3-judge decision, which means it's going to be binding precedent and also requires certain internal things to be done by the board. Another classic example besides the 90 days is whether or not there is a claim in the first instance, basically attacks on the validity of the claim, whether or not it was a claim in the first instance under the CDA, and whether it actually covers the matters that are in the complaint. Well, those are the kinds of things that are also subject to motions and to dismiss. And finally, there might be circumstances where it's a motion to partially dismiss. Oftentimes, when a contractor files an appeal to the board and then files their complaint shortly thereafter, they might have certain counts of the complaint that go beyond what are in the actual claim in the first instance. Sometimes that's okay, but sometimes it's not, depending on how far you depart from the claim. So what you might do is say, well, yes, there is a contracting officer's decision for them to appeal, but counts 7, 8, and 9 are beyond what was in the COFD, was in the claim in the first instance. And you can ask to have those dismissed so you can narrow what's before the board. It all depends on the facts and circumstances. And again, not every case is going to have a basis for a motion to dismiss. But if they're appropriate, there's no reason why you shouldn't do it, and do it early so that the board can not basically expend any time on a case where legitimately it is without jurisdiction to consider it.
Yeah. Now sometimes we get a defective certification and we're excited. We think they didn't follow the rules. Is this a great grounds for a motion to dismiss?
Great grounds, no. Because as you all know, it used to be when the CDA was first passed that a defective certification or was no certification as basically meant that the case would go away. There was no good claim. But obviously people make mistakes in certifications and it seemed like a very big gun to use. So Congress amended the CDA to allow people to basically cure defective certifications. Now there's no reason for you not to bring it to the attention of the board. You can do that in motion to dismiss, you can do that elsewhere, but the ultimate end result is going to be that we're going to say, you're right, that is a defective certification, if in fact it is a defective certification in the circumstances, and then basically allow the contractor to fix it. And the contractor basically has until its final judgment is entered to fix a defective certification. So, and in fact, you might think, well, there's a defective certification and then there's a way defective certification, but the CDA doesn't distinguish between how badly defective the certification is. So, as long as it is actually from the contractor and it's defective, it can be fixed. So, you might not waste your time in a motion to dismiss just on that, but frankly, you might want to bring it to the board's attention at some point and basically make sure that there is some order or some recognition that, they have to go and fix the certification, which they will do before we move forward.
And there may be something to say about the last episode when we talked about discovery disputes and reaching out and trying to resolve things without necessarily getting the board involved, depending on the circumstances and your strategy for the case. Perhaps it's not worth irritating the board if it's something that defective certification can be remedied. That's something that you're going to have to tactically decide case by case. But it is nice to hear that it's not an instant trigger for ticking off the judge to bring up something like that.
It's a legitimate issue.
Yeah.
And nobody's going to think worse of you for raising defective certification, but it's going to be something that can be fixed. So don't go in there thinking, I've got them, because you don't.
I'm guilty of that. Early on, there were a couple of times I thought, they didn't follow the rules. Yes, there's some leeway there. There's some leeway on certifications. Well, motions to dismiss are something you should look at for every one of your cases. Is jurisdiction appropriate? Has the 90-day rule been followed? But you're not going to file a motion to dismiss in every case. I think that we need to talk about summary judgment motions because there's a slightly different perspective on how important summary judgment motions are, how applicable they are when you use them. And we would love to hear your insight and your thoughts on summary judgment motions. So why don't you all come back and join us again for the next episode of Between Two Fars.